My name is Philip Landolt. I'm the chair of the European branch of the Chartered Institute of Arbitrators. Today, we are gathered with a very distinguished group of panelists to discuss a very practical topic in arbitration, choosing arbitrators. It is said that the arbitration is only worth as much as the arbitrator is worth. That is a very strong statement. Nonetheless, there's a degree of truth in it. More so than even judges, arbitrators wield immense power. As you know, there's very little you can do to police an arbitrator's decisions, both in procedure and in substance. Arbitration systems usually grant searching deference to what arbitrators decide. And as a result, arbitrators, they can do largely what they please. So when you choose the arbitrator, you're going to want to make sure that you're getting someone or a team of persons who you can trust and whom you can predict in their actions. And by consequence, you're going to set the stage for the rest of your arbitration. Things can go very well, things can go very poorly. And today we're going to have a look at how practitioners, experienced practitioners, approach this crucial matter. We have with us today, well, let me just say that this webinar has been organized by Jacob Jørgensen, who is a distinguished Danish arbitrator who effectively concentrates on construction arbitration, but not only. Jacob was called away to a hearing, so I am standing in for him. Our first panel is Steffen, and Steffen is Secretary General of the Danish Institute of Arbitration. Steffen has been so since 2006, which is quite an extensive run. I think you are the doyen of Secretaries General in arbitration, major arbitration institutions, Steffen.
Yeah.
You have been therefore able to see the evolution of arbitration, and in particular how arbitrators are chosen both by the parties and by the institution itself. A very important perspective indeed. Steffen has seen 1,500 arbitrations in his time from the inside. So this is, as you can see, very valuable indeed. Our next speaker will be Professor Dr. Solveiga Vilčinskaitė, who is a Lithuanian arbitration practitioner with TGS Baltic, a professor and a practicing lawyer. She's chair of the Baltic chapter of the European branch of the Chartered Institute. And she specializes in, I think you've gone out and chosen the most complex areas of law, Solveiga: complex state liability issues, protection of human rights, international investment in commercial disputes, unfair competition cases. So the only thing I can see that unifies all those categories is that they're very, very complex. Next, we'll hear from Charles Marquand. Charles is both an English barrister and a French avocat. And that is already suggested by his name, which looks very Anglo-French. And he has been acting as an arbitrator for 25 years in both civil and common law jurisdictions. Interestingly, Charles has two specialties, which, in my opinion, don't appear to have much to do with each other. To begin, he's specialized in metals and in finance. Maybe Charles will have an opportunity to tell us how to square that circle. And then fourthly, we'll be hearing from Vlasenko, who is based in Paris and has a very broad, general, international background. Interestingly, Yanina has, it seems to me, achieved 3 master's degrees in international arbitration-related subjects in the last 3 years, which is quite an extraordinary achievement. That's a lot of work indeed. Yanina has practiced arbitration with a great range of names, great law firms in this area. We'll be hearing from Peter Namias as well, who is based in Spain, and he is a Spanish lawyer, and he's focusing on arbitration in highly regulated industries. And so Peter is going to be telling us about how things work in Spain. And he'll be backed up by Nazareth Romero, who's a Spanish practitioner and chair of our Iberian branch of the European branch of the Chartered Institute. And Nazareth is a very dynamic arbitration practitioner who has been extremely supportive of the European branch and this series of webinars. And Nazareth will be intervening, as she feels is appropriate. I'm just going to say that I think I've introduced everybody, so it is time for us to begin in that order, but I will first encourage you all to ask questions over the Q&A, and we will, generally speaking, deal with the questions after each presentation. But if a presenter sees the Q&A and wants to address a question during her or his presentation, she or he is most welcome to do so. Well, that's all from me, and let's therefore begin by hearing from Steffen Pihlblad. Steffen.
Thank you so much, Philip, and thank you for stepping in here in the last minute for Jacob. And thank you for the kind introduction, and thank you to the Chartered Institute for inviting me to this webinar about a topic which is dear to my heart, and a topic which is sometimes not paid sufficient attention to. As you said in your introduction, choosing arbitrators is an essential step in every arbitration. And it's a key principle in arbitration that the parties themselves may appoint the members of the tribunal. And this is considered as a significant advantage of arbitration compared to litigation, where the parties have, at least in Denmark, zero influence on the composition of the court. Under Danish law, the parties are generally free to appoint the arbitrator they prefer. Lawyers, professors, and judges from the courts are very often appointed as arbitrators in Denmark. Other professional groups, such as architects, engineers, accountants, are also appointed, but to a much lesser extent than the other professional groups that I mentioned. And within the next 15 minutes, I will give you a few perspectives from an institutional angle. As Philip said, I've been around at the Danish Institute for many years and seen a few appointments in that connection. There is a lot of gray hair on the heads of the arbitrators, if they have any hair at all. At the DIA, we appoint a lot of very experienced arbitrators and mature individuals, I would say. But we also appoint younger arbitrators. And generally, I would say that we have very positive experiences with younger talents in the field as arbitrators. Generally speaking, young arbitrators are fast and efficient. They are determined to comply with all the institutional rules, to do anything and everything right in a timely and efficient manner, to ensure that they are appointed again in new cases. So they are doing efforts to climb the ladder as new in this game. Another good thing about younger arbitrators is that they have tech savvy. They have a good approach to, for instance, the use of AI. They are embracing it and using it to perform better and faster without compromising the quality. Many older arbitrators would argue that AI has no place in arbitration at all. And I think many, or at least some, will disagree with that, at least within a couple of years. Younger talents are proactive for instance, they reach out to the institute to discuss complicated procedural matters before making decisions, which I think is a constructive and good approach. They are cost effective. They charge lower hourly rates than older and more experienced arbitrators. Of course, there are disadvantages by appointing younger talents as well, generally, and this might be a bit controversial. Younger arbitrators, in my opinion, tend to have maybe too much respect for the principle of due process when trying to conduct proceedings appropriately. Of course, any arbitrator should have major respect and pay major attention to ensure due process. But sometimes arbitrators, and maybe especially younger arbitrators, struggle to draw the thin line between what constitutes due process and what does not. My sense is that we don't see this issue to the same extent among older arbitrators, and this is perfectly understandable, as experience is crucial in determining where due process limits the arbitrator's discretion. In fact, this tension between due process and the arbitrator's discretion is one of the hardest aspects of being an arbitrator, at least in my opinion. So my recommendation to parties when choosing arbitrators is to consider selecting a young talent. Not every case requires a top-tier, highly experienced arbitrator. Regarding availability of the arbitrator, availability is a term that arose maybe 15 or 20 years ago to help prevent delays caused by the fact that highly regarded arbitrators are often busy people. Arbitral institutes ask prospective arbitrators to disclose their availability, to act in accordance with the requirements in the institute's rules, and of course the parties' agreement or arbitration clause. And the aim with this arbitrability discussion is to save time and costs. However, the problem is that an arbitrator who is available today may become unavailable tomorrow. You never know what might happen. And the other way around, an unavailable arbitrator might become available tomorrow, for instance, if one or more of the arbitrator's cases settles unexpectedly. These things happen in practice. From time to time, we see arbitrators disclose practical issues such as I will be on leave for the next 6 months, or I will not be able to attend a hearing in November or December. Such information is, of course, valuable for parties when they need to organize things in order to get a fast decision to settle their dispute. But my point is that just because an arbitrator declares that he or she is available, it does not mean that the proceedings will be fast and efficient. Therefore, the requirement for availability may sometimes be more or less wishful thinking. The discussions about availability have sparked focus on developing case management skills, ensuring that proceedings are conducted appropriately and efficiently. My recommendation to parties is to prioritize arbitrators with strong case management skills rather than focusing on their availability, except, of course, for the practical circumstances that I mentioned just before. The parties rarely agree on the specific expertise that the arbitrator must possess. Sometimes the arbitration clauses contain certain requirements. For example, we had a case at the DIA here in Denmark, where the parties agreed that the president of the tribunal should be a Supreme Court judge. In Denmark, we are allowed to appoint sitting judges, and the clause said that the president should be a Supreme Court judge with business expertise. All the Supreme Court judges we approached declined the appointment. I'm not sure of the exact reason, but I believe that they were hesitant about being put in a position where they would have to demonstrate their business expertise.
Yep.
Bearing this in mind, I would advise you to avoid agreeing on overly narrow or vague qualifications, as this could make selection of arbitrators unnecessarily complicated. That said, there are often strategy considerations when deciding what expertise an arbitrator should have. I have even seen here at the DIA parties appoint lazy or maybe even incompetent arbitrators, which is something that at least initially surprised me. However, it may have been a strategy choice in a case where the party had weak arguments. And under such circumstances, it may be an advantage to have an incompetent arbitrator in the panel. Maybe, I'm not sure about it, but that's at least a statement to consider. My recommendation is, of course, not to appoint lazy or incompetent arbitrators. Select someone with expertise, not only on merits of the dispute, but also in conducting arbitration proceedings smoothly and efficiently, which I mentioned before regarding case management skills as well. It may be tempting to appoint an arbitrator whom you believe will be biased in favor of your arguments and perspective on the case. I can't recommend such an approach. In practice, if an arbitrator is biased, the other arbitrators will quickly realize it, and that would leave your arbitrator without influence in the deliberation room, and of course it's a very unfavorable situation for you. Generally, you are much better off choosing an arbitrator with high integrity and who is independent and impartial. The question of independence and impartiality is one that arbitral institutes have very much focus on under Danish law. Arbitrators are required to disclose any circumstances that might give rise to justifiable doubts regarding the independence and impartiality. To assist the arbitrators with complying with this duty of disclosure, the DIA asks prospective arbitrators to sign a declaration addressing these matters. For instance, we put in the declaration that or try to address the fact that we sometimes see a party, a lawyer or a law firm appointing the same arbitrator again and again. To ensure transparency, we ask arbitrators to disclose such patterns. And if an arbitrator has been appointed previously by one of the parties, we ask some detailed questions to create this transparency. Sometimes a party wishes to interview a prospective arbitrator as part of the selection process. I don't have strong views on that. I guess such interviews can be helpful in many ways. For instance, when assessing whether the arbitrator has the right personal skills for the specific case. However, the intention with such an interview cannot be to reveal whether the arbitrator will favor your side when deciding the merits of the case. Of course, my recommendation about independence and impartiality is to select arbitrators with high integrity and to avoid those whose independence and impartiality may be in question. We spend a lot of time on promoting diversity and equal representation in arbitration. It's an important goal and in the arbitration environment and at all the institutes. The DIA has, along with other institutes, law firms, organizations, and individuals, signed the Equal Representation of Arbitration Pledge, which promote gender diversity in arbitration. Some may argue that finding female arbitrators with the right qualifications is a challenge. I want to underline that, in my opinion, women are just as capable as men in serving as arbitrators. There's no difference in their ability, in my opinion. It may take a bit more effort to identify suitable female arbitrators, but investing this time will lead to the selection of excellent arbitrators. So I strongly recommend parties to make this effort. I will finalize my short speech here with some remarks about appointing judges, sitting and retired judges. As I mentioned in my introduction, according to Danish law, we are able to appoint sitting judges from Danish courts as arbitrators, and this is regularly done. And in general, my experience is that judges are highly qualified arbitrators. Some state court judges even carry kind of certain authority or gravitas that can enhance the proceedings. Judges have extensive experience chairing proceedings and handling procedural issues, as well as drafting clear and precise decisions. The appointment of judges as arbitrators rarely raises concerns about independence and impartiality. There are some disadvantages, in my opinion, with appointing sitting judges as arbitrators. At least in Denmark, a sitting judge's role as an arbitrator there's a cap on how much income a state court judge can earn from such side jobs. Occasionally, judges simply withdraw from cases when they approach this limit, which of course is an unfortunate situation for the parties who thought they were about to finalize a case and then realize that the judge had withdrawn from the case. A sitting judge's role as an arbitrator is a supplementary occupation, and that means that it shall be conducted outside the normal court hours. And as a result, scheduling hearings, especially the lengthy hearings, can be a challenge as well. Another concern about appointing sitting judges is that the judges might conduct the proceedings as if they were court cases. Arbitration is fundamentally different, and there is a risk that the advantages of arbitration may be lost if the arbitrator consider the arbitral proceedings as any day in court. As to retired judges, they can be an excellent choice as well. They are generally more available and are not subject to income caps like the sitting judges. However, their age may be a consideration, particularly in cases expected to last for several years. I think my time is up, Phillip, so I will leave it to the next speaker to carry on the torch.
Yeah, Steffen, that's a uniquely insightful perspective and set of comments. I mean, I'm always curious about how things work from the inside. It's crucial information. I'm hoping that there'll be an opportunity for us to return to you. And of course, I invite you, Steffen, to comment as you'd like on anything else that's said subsequently. But we do have a couple of questions from participants. Golem Dastiger asks about, the relationship between young arbitrators and industry experience. Is there a real trade-off when you're coming to a decision about appointing a young arbitrator? You're thinking, oh, yes, it'd be nice to get that speed, that ability with information technology, but they probably don't know an awful lot about letters of credit or anything technical. They just don't have industry experience. Is that the sort of the thinking, the conceptual frame you're working in when you're making that decision to name a young arbitrator?
Well, of course, it is an overall assessment, and industry experience is certainly an important factor when appointing arbitrators. But speaking of young arbitrators, I would say that it's people in the late 40s and the beginning of the 50s, and people at that age would certainly, or at least many people at that age would certainly have industry experience already. So I'm not that concerned about it. And as in any other case, it's also up to the parties to explain all the details and the effects and the law and the case to the arbitrators. And usually that would be sufficient for younger arbitrators to pick up the industry points, which they may not be so experienced with.
Yeah. So in your experience, you don't find yourself, supporting, a little more any young arbitrator, and trying to guide them about, the way of the world. You find that they tend to make their way as arbitrators pretty well.
Yeah, we have this arbitrator education in Denmark, which is international education. I think it's 7 full days, and we have had it around since the beginning of the year 2000, and I guess maybe 500 participants have taken this education, and it's you have to start one at one time to gain experience. And as I said, as an institution, we have a very much focus on this issue in order to give this younger talent experience, so they can take over from the older and more experienced guys when they decide to retire. What I said should not in any way be understood as if we don't want to appoint the more experienced and older arbitrators. But as an institute, you also have at least some cases which have a very low value. The amount in dispute is maybe 100,000 euros or even less, and those cases are really perfect to gain experience from. And those younger talent don't care about the fees. They just put every effort to learn from the case, and that's the right spirit. And as I said, we have really good experiences with it.
Yeah, excellent. Okay. Would you ever consider choosing a young arbitrator who hasn't taken that 7-day course?
Yeah.
It's still open. You don't have to have that.
No, if young talents have proved their worth as party representatives in big arbitrations, or if they wrote articles about arbitration or even books or speakers at seminars and so on, I wouldn't hesitate to appoint them, even though they haven't taken this course. But of course, it's a good thing to take the education.
Okay, what of their fellows of the Chartered Institute of Arbitrators?
That's even better.
I like it. Well, it's really interesting to see the thought process for all the young aspiring arbitrators out there. You know, you have this reflection, you know, how someone who bears the ultimate responsibility for who gets selected as the arbitrator goes about this very serious business. We got another question from Leonor Aguera Yatshakameh, who asks about your comment, Steffen, that it might take a little more time to find suitable female arbitrators. So what's happening in those circumstances? Why a little more time to find a suitable female?
At least that's what we hear. The party representatives tell us that the clients have asked for a list with 3 arbitrators, and they make a list with 3 500-pound gorillas, male gorillas, and the client would say we need at least 1 nomination of a female arbitrator as well. And everybody is stressed and concerned. We can't find a female arbitrator with the qualifications we need in this very big and complex arbitration. But after looking for it and after discussing the matter with your colleagues and maybe with the institute, they will eventually find a very good candidate to put on the list. But it's at least in Denmark, it's not that I guess the institute, we make some statistics about it due to this pledge we take. That's an obligation due to this pledge, and I think the institute are appointing around 30% female arbitrators. But when it comes to the parties, when they appoint arbitrators, it's around 10%. And I would say that if we can appoint 30% of the arbitrators, the parties should be able to do the same. So it's in my opinion, it's just force yourself to put some more effort in finding the right profile, then you will find it.
Okay, we really do need to move on, but I cannot help but ask this question. Is there something about the women who get appointed, that 10%, that's sort of common to them, that really makes them compelling candidates to get appointments? Something that could be interesting to some of our female practitioners out there.
I guess the 10% that are appointed is also among the 30% that we appoint at the DIA. And maybe it's easier in Denmark to appoint female arbitrators. I don't know about it, but it may be a bit easier because we are allowed to appoint sitting judges, and sitting judges in Denmark is, except for the Supreme Court, maybe it's around 50-50 male and females. But look at look who's speakers at the IBA annual meeting or the ICA conferences or the Chartered Institutes events. You will find a lot of females, and they're excellent people, and they determined to do a good job.
Yeah, absolutely. You know, they say it's to a degree a legacy issue. It's taking a while for people to come through the ranks. They say arbitration is a terrific career if you can survive the first 20 years. You know, it takes a while to
yeah,
make it.
That's right.
Okay, well, that's absolutely terrific, Steffen. Many thanks indeed. Now we'll hear from Solveiga, Professor Solveiga Vilčinskaitė, about, as she frames it, a regional arbitration market, in particular the Baltic arbitration market. Solveiga?
Thank you, Phillip, a lot for giving me the floor to speak and be the second in the panel. I would at first reflect a bit maybe this issue concerning diversity and women appointments, women as arbitrators a bit. My goal in general is to speak about our regional issues we meet when finding the right arbitrator. But reflecting a bit to this situation concerning diversity, I think we have in Lithuania the same situation. The considerable number of arbitrators in our national arbitration cases are men. There are less women, I think more women than when in Scandinavian countries, perhaps, because in general we do not have a big number of arbitrators practicing as arbitrators, qualified and devoted to this work. And there are, if you go to the statistics in general, who are practicing as arbitrators, for example, in Lithuania, I think it would be even more than 70% as women. But eventually, those who gets arbitration cases usually are men, and the chairman or chair, those who chairs tribunal are women, because usually they are eager to take all the hard work on the case. And it's a very big pity that in Lithuania, and it's a big difference is that we are not able to appoint a judge as arbitrator, because in judicial system, I think we have 80% of women in general in all our system. And they are really very qualified, hardworking, very well known, and I think could act and be a very good arbitrators. At this point, I really know from my practice, this complex practice and complex issues you pointed out, Phillip, in my CV, because I usually used to work around 10 years at the Supreme Court, and then also have experience very political in the government and president palace, and responsible for all judicial system in Lithuania many years ago, and now already 10 years in advocacy and in litigation and arbitration, because we have no privilege to specialize only in arbitration, because rather small small number of cases of arbitration in Lithuania. So even though arbitration is really key point topic for me, but the real life dictates its own issues, and we have to work also on number of litigation cases. This is not bad in general, because you become much more experienced. And coming back to the problems and issues, let's say very specific ones, apart from the general. Steffen already mentioned impartiality, independence, availability, qualifications, and other issues you have to take into consideration when you choose arbitrator. In the Baltic states, we have our own, let's say, issues, and let's speak a little bit about it. So, for example, in Lithuania, we have one arbitration institution. It's called Vilnius Court of Commercial Arbitration, and it's very solid, I could say, a list of registered arbitrators. I checked several days ago. It's about 200 recommended arbitrators in our list. There, in this list, you can find nationals, really qualified, with all necessary credentials from most prestigious universities and so on. And also we may find even in that list international superstars. So it's, at the first glance, it's not a problem. And even then, under our rules, the parties are not obliged to choose from the list, as usual. Now, however, the reality is that when you really want to find the right candidate, practicing, experienced and qualified, you usually circle around among 10 or 15 names. And even then, the problem is that most candidates, they at the same time work at Big Four law firm or other law firm, and it's often difficult to find the one who could go through conflict of interest check. So if you, for example, have a big case among big business partners in Lithuania, You have Lithuania as a seat, Lithuanian legal system, and language Lithuanian. You may meet a really big challenge to find the one who knows Lithuanian legal system. Of course, you can change it with the foreigner with the similar system, but it's very difficult sometimes to find the one who can handle the case in Lithuanian language. Because there are only few practitioners who work outside Lithuania and not connected with our business and may not have conflict of interest. And there are only some of them who just work solely as arbitrators, let's say. Even bigger problem you may have in Latvia, because, for example, if you have arbitration clause with Court of Arbitration of the Latvian Chamber of Commerce, so, for example, until 2024, the parties were not permitted to appoint arbitrator outside the list. And the list was very small, only 22 arbitrators in the list. It led actually to Latvian legal authorities and academic debate this problem. And eventually Parliament, but only in 2024, it changed the law, and now the parties are free to choose the right arbitrator outside the required list. So maybe in the nearest future it will solve the problems with upcoming cases. What solutions to this problem can be, because in any case we must have a solution if we have a case. So of course, usually the parties should think, and the community in general should think from the broader perspective and should think in advance. Maybe for smaller national cases, you have to choose just the court as your dispute settlement body. In a bigger cases, but it's really happens now with the bigger contracts and bigger business in Lithuania, we even national ones, we choose bigger arbitration institutions, or we change our language. We consciously choose not Lithuanian language of contract and arbitration, but we choose English language, because then it solves many of problems and gives you a broader range of possible candidates for arbitrators. Of course, when you have a dispute, the only way is then to agree with the opposite party to change the language and give possibility to be a foreigner in your arbitral, let's say, tribunal. But more fundamentally, looking forward to the situation, I would think what our community should inspire to more academics to go to and practice arbitration and become sole arbitrators. And also what I would suggest to take example from the Danish system, where judges can be appointed as arbitrators, active judges, because in Lithuania it's still not impossible. Only retired judges, they may be included to the list and become arbitrators in the case, but practicing they are still not allowed. But it's really a very good example, and I think a good idea, at least for Supreme Court judges, to give possibility to be appointed to the arbitration case. So this is the specific points I wanted to take into your attention, and I would not dare to take more time from the other distinguished speakers. Thank you.
Many thanks, Solveiga. Is there any course of studies in the Baltics that one can follow in order to improve one's qualifications to become an arbitrator?
In general, our arbitration institution organizes such courses, because if you are not even allowed to be included to the list if you do not go through those specific courses. So there is possibility to get those let's say training. It's not a problem, but as I told, we have most of practicing lawyers, they are already used to take all education abroad.
Okay.
I myself, I finished 10 years ago MITS program in Geneva. Number of my colleagues, they go to London, to Queen Mary, or Paris, they take LLM. So it's not a problem.
Okay. Have you ever found yourself in a situation where you see a party appointing a person to be an arbitrator, and you know something about that party, that arbitrator, and you really don't like it, and you feel that you must intervene? Has that ever occurred to you, and what do you do in those circumstances?
Yes, of course, we know each other, and we have small market, and everybody knows everybody, and sometimes it happens so. But I usually learn through life one golden rule: either you kill or become a friend. So if you have no enough evidence and to challenge, so better not try to do this.
I agree. Yeah, if you're going to challenge someone, you really need good grounds. Absolutely, especially because if you lose, you're going to, you're still going to have power over your case. Absolutely.
Yeah.
Yeah. And what is the average age of the people you see acting in the Baltics as arbitrators?
What do you mean by
average age? What would you estimate the average age is?
They are rather young, because in general our community, lawyers community, even judges are really very young. It's like 40, 45, it's really average age. 40, for example, me, I'm 40, well, 46. So it's among my colleagues, I found the considerable number of arbitrators acting like in that field, because the much older one, they used to live in still in the Soviet Union.
Yes.
Even the same with judges, and it's a big problem. Many of them, they could not adapt themselves to the changes of the system. So there was the flaw for the younger generation to step up. And I think we were one of the first generation who stepped into. And now, for example, you can find even the judges of European Court on human rights and others of my age.
Okay. Do you find yourself as a Baltic practitioner being considered for arbitrations in particular circumstances by let's say the big arbitration institutions like the LCIA, the ICC? I'm just thinking, as between, for example, the Nordics and maybe Germany, loads of commercial deals. You guys are sort of, I guess, neutral and knowledgeable.
Some years ago, there were not many invitations or appointments, but now what I noticed, the situation is changing, because our countries becomes, all the community members of our countries like Eastern Europe and even Poland and others, they become more active, more proactive and cooperative, let's say, and we ourselves and other parts themselves having, for example, ICC arbitration, SCC arbitration, and other clauses. We already started to appoint our colleagues, and the institutions, the policy of institutions have changed a bit, because the board members, they are more diverse, let's say. There is some diversity in a board member. For SCC, we have Lithuanian board member, Udzevičius, in LCIA also from Lithuania. So our voice already is really, you can hear. You can hear us, and I think in the future there will be much more appointments. And actually, we can handle those cases now, because, as I told, a big number of our community members, they are really very qualified.
Yeah, I'm seeing people from the Baltics more and more in the arbitration world, absolutely. And as you say, young people like yourself, it's a real opportunity for your first generation. A country on a new trajectory to establish yourself, in the region and also internationally.
Yeah,
okay.
Yeah.
Solveiga, thanks so much. We're going to move on. It's now Charles Marquand's turn to talk about, probably not just choosing arbitrators in the metals and finance sectors. Charles?
Thank you. No, I'm not going to confine my remarks to those, because I don't think they give any particular lessons. I want to look at the question of appointment of arbitrators through what are sometimes called the 3 A's that you should consider when you appoint indeed any professional, So the three A's that are often mentioned are availability, affability, ability, in that order. And then lastly, sometimes a fourth is added, which is affordability. So to consider those particular themes, but to subvert their order, I think if we start with availability, obviously, if an arbitrator is not available, then he can't be or she can't be appointed. But I think availability actually goes beyond the actual ability to attend to a particular arbitration on a particular day or dates, and extends to the sort of caseload that the arbitrator has. Whilst the arbitrator may be, technically speaking, available to hear or deal with an arbitration on a given day or dates or period, I think there is sometimes the problem that arbitrators with very heavy caseloads aren't really, properly speaking, available to give their full attention to the arbitrator in which they've been appointed. I mean, to give an example, which I heard of from names obviously must remain confidential, I'm not going to give them, but this was an instance given to me by a lawyer at a leading international law firm about a leading international arbitrator who had set down a tight timetable for the delivery of written argument on a particular important procedural issue. The team on this particular arbitration at this particular firm worked very hard to produce extensive arguments on this point, as did the other side. And within the space of about an hour, the decision was rendered by the arbitrator. There is no way that arbitrator can properly have considered that particular point in such a short space of time. That arbitrator must have, in effect, come to a decision and decided to issue it very quickly thereafter, clearly because that arbitrator was not really available. So I think what I'm saying here is, yes, availability goes beyond simply whether or not somebody is available for a particular arbitration on a given day and dates and periods, but actually look at the caseload to a certain extent, because that can also have a bearing on the availability of that arbitrator in a real sense. The second aspect of availability that I think is important, if I can stretch the term a little, and I'll be doing a lot of stretching during this talk, is independence and impartiality. If an arbitrator is or appears to be related to one of the parties or partial to one of the parties, then quite obviously that arbitrator is not available for that arbitration. So that clearly gives or places on an arbitrator a very important obligation to disclose connections and conflicts, and indeed I think perceived connections and perceived conflicts, because the arbitration not only has to be fair but also has to be seen to be fair, and if in effect it's not seen to be fair, then the award is going to be vulnerable to challenge. Steffen raised the point, what happens if it becomes clear in the course of an arbitration, perhaps clear to the other arbitrators, that an arbitrator is biased or partial to one of the parties? I think he gave the answer that the other party, the other arbitrators will just simply not take into account or give full weight to his or her comments during the course of deliberations. So I think really what one's saying here is it's not an arbitrator that is chosen by a party is not someone who is going to argue that party's case in the deliberations. That's not a criterion that really should enter into the parties' heads. Rather, what I think one's looking for, or should be looking for, is expertise, which I think brings me to my next A, in slightly subverted order, which is ability. Seems to me that there are many elements that fall under this particular heading. as I've just said, what an arbitrator is really supposed to be bringing to the table, to the discussions, to the process, is his or her expertise. But I'd say that I think expertise is not really the same as detailed factual knowledge of the subject matter. I think this is less a problem, if I can say, with lawyers, more perhaps a problem with experts such as surveyors and so forth, who may be appointed sometimes in arbitrations. But for an arbitrator to decide a case on his or her expert knowledge, rather than on the arguments or the evidence that's put forward by the parties or by an expert appointed by the parties, it seems to me would run the risk of jeopardizing the fairness of the arbitration and soundness of the award. What I think, what I mean by expertise essentially is an understanding, a broad understanding of the subject matter of the industry, or whatever it happens to be, that is the subject matter of the dispute, so that the arbitrator can ask intelligent questions and doesn't have to have, if you like, a crash course given by the parties during the course of the arbitration to bring him up to speed or her up to speed on the relevant issues. Another element which I think falls under the heading of ability is what I like to call maturity. Now, I don't mean age here. I think maturity and age needn't necessarily go hand in hand. What I think I mean by maturity is confidence. That's to say, a confidence to take decisions, firm decisions, and if they're not respected, to enforce them by means of peremptory orders and that sort of thing. Effectively, a confidence to come to firm conclusions and not waste time about it. It also means, I think, a confidence to, on the part of the arbitrator, to, if you like, admit that he or she doesn't know everything, and to ask questions of the parties, and sometimes actually very obvious questions. I mean, my experience is that an obvious question can actually sometimes throw open all sorts of issues, or throw up all sorts of issues, and expose weaknesses in parties' cases, which can be very useful. Stefan mentioned the appointment of judges. Now, in England, I'm not aware of a single sitting judge who has been appointed as an arbitrator. Plenty of ex-judges. I think, well, certainly there is a problem of availability, and I doubt that the court service would be willing to release a judge to do an arbitration so that he or she can line his pocket. I think there would also be problems about the degree to which the judge would be exploiting his or her official function for private gain. So I don't really think the problem arises as far as the appointment of judges is concerned in England. The same, I think, applies in France. But I think, so I'm going to sort of speak, if you like, from the point of first principle here, rather than direct experience. It seems to me that, yes, clearly judges have got characteristics which are helpful in an arbitration, but arbitration is not the same as a court hearing. It is consensual. It's consensual as between the parties. They've decided to have arbitration. They have the ability, there is party autonomy to decide on procedure. They can take ad hoc decisions. And it's also consensual as between the arbitrators, if there's more than one of them. And I think perhaps judges can be, well, they've had a professional experience, if you like, of being masters in their own courts, and may therefore emotionally have perhaps less flexibility than those who have not been judges. That's all really I can say. That's not to denigrate judges who do sit as arbitrators and quite successful arbitrators. But again, anecdotally, I've heard stories of very superior, very important judges from superior courts behaving in an offhand and high-handed manner, which I don't think which might be appropriate in a court. Well, probably not, but certainly inappropriate in the context of an arbitration. So I'm going to sort of equivocate. Yes, if you will, do appoint judges, but not always. Think carefully, I guess, about the judge, the character, and so forth. The third A is affability. Now, clearly, if someone is unpleasant to deal with, then unless it's absolutely essential, it's probably not a wise move to appoint that person. But I think we can stretch affability to cover another characteristic which has already been touched on, which is diversity. Diversity as to sex and to ethnic background, and perhaps also age. There's clearly a problem that if one has, or a phenomenon, excuse me, if one has experience of a particular arbitrator, one may be tempted to choose that arbitrator again, and indeed even again and again and again. And that's going to raise questions and problems of independence. There's also, I suspect, I'm sure, a tendency to appoint arbitrators that were a bit like oneself, perhaps the same nationality, because it's comforting. You think you understand how that particular arbitrator is going to react, and so forth. Same vein, if you have sat with an arbitrator before as a fellow arbitrator and got on with that particular arbitrator, you may be tempted to choose that arbitrator as the president of the tribunal. All of this is understandable. I think one just has to be conscious of these biases, these unconscious biases, if you can, be conscious of an unconscious bias, and recognize that they exist and try to be objective. There's another point which is very, very obvious, that if parties or arbitrators continue to nominate in these particular ways, you will never extend or expand the pool of available arbitrators, which cannot be a good thing for arbitration as a whole. So I would sort of try and hedge my bets to a certain extent and say, well, look, yes, you go for expertise and other various characteristics, but try to think outside the box. Because if you don't, ultimately, arbitration will get a bad name and it'll atrophy. And it's probably not a good idea for the particular arbitration you may want to bring in some fresh blood, a different perspective. It can be useful. It can be helpful. It can be helpful. My fourth A was affordability. Now, of course, in many cases, an arbitrator's fees will be determined by the institution, but that won't always be the case. I would have said, well, obviously, if you haven't got the money, you can't appoint a particular arbitrator, but it can't be the only consideration. There is, I think, higher up the list, the other characteristics that fall under the other headings that I've just spoken about, expertise, maturity, and so on. Perhaps rather equivalent to swearing in church in front of my fellow panelists and probably the audience too. I'm going to say that not all cases are suited to arbitration. Perhaps even if there is an arbitration clause, if the amount in issue is low, particularly if the parties are actually in the same jurisdiction to take food out of the mouths of my children, it may not actually be very cost effective to go to arbitration and to agree to go to court instead, because you might well end up spending a great deal less money and get a result which is equally satisfactory. So those are the points that I wanted to raise. I'm here for questioning.
If any of the panelists has a question, please do ask it. I was interested, Charles, in your comment about people choosing arbitrators because of the comfort factor. You identified two potential explanations for that. The first, you said it's because there's a feeling that you want someone like yourself, and secondly, you may have worked with that arbitrator. I'm thinking that what's really happening, and what perhaps the biggest motivator for the choice of an arbitrator by a party is that there's a relationship. For example, when I'm choosing arbitrators, I always want to have a certain relationship with the arbitrator. I want to know them, not just for their legal work, but just a little more broadly, if possible. How they act, how they think, what their values are. Are they people who really get the job done? What do you think about that? What do our panelists think about this? Is the crucial factor, the overwhelming factor in choosing an arbitrator, a relationship with the nominee?
I don't quite understand the question, Philip. A relationship, you say, with the nominee? You mean?
Yeah. Well, some people go to lists. For example, in Switzerland, we have this as a list of arbitrators, and there's a whole bunch of distinguished people. Many of them I don't know, and I would be, in these circumstances, just not comfortable, to use Charles's term, in nominating that person as an arbitrator. What I would tend to do is I would go for someone I've actually, seen at a conference, seen speak, talk to, maybe someone whom I've golfed with, or someone, maybe I've worked on in a case as co-counsel, someone who's been an arbitrator already, in Charles's example, that I've seen in action, but whom I've talked to at the break, and seen the sort of person they are. Is this, in your experience, the crucial thing, that there's a relationship of that nature, not just a pure sort of legal relationship, not delving entirely into the private, which would cause a problem, wouldn't it, if there's a very close relationship? But in my experience, it's not just me. People who are nominated as arbitrators tend to have a relationship either with counsel or the party counsel is representing.
Would you like me to come back? I'm happy to.
You start, Charles, please.
You've raised a very important point, I think, and I think it really. I mean, it seems to me there's the spectrum, isn't there? If you've seen somebody speak at a conference in some kind of professional environment, I don't see a problem at all. If you've sat next to that person at lunch during the conference for the sake of argument, or spoken with them during the coffee break, I don't see a problem really. It gets to be, I think, a bit more of a problem if, to use your example, you've gone out and played golf with this person. It goes back, I think, to the point that arbitration, I mean, this relationship may have absolutely no bearing whatsoever in fact on the arbitral process. But the arbitral process, I think, has got to be not only fair, but seen to be fair. And I mean, it's something I have at the back of my mind too. If you get too close, too friendly, is this actually going to contaminate or be seen or be thought to contaminate the independence and the impartiality of the arbitrator? And it's, I think, a very difficult question. You can't really answer it, it seems to me, in the abstract. It's a question really you can only answer in the sort of particular circumstances of the case. And I appreciate you just see a name on a list and you've never heard of this person. That's going to be, gosh, well, why should I appoint this person? I know nothing about him or her. You can, of course, take soundings from other people. You can do all of that kind of thing. But really what I can do is sort of caution, don't be too close. I mean, maybe the arbitrator, him or herself, will say, well, look, I'm going to have to disclose the fact that Phillip and I went, you know, in a golfing tournament together.
Yeah. Okay. Yeah, I mean, there's no doubt there's a danger that the relationship is too close. The thing is to get it, close, but not too close.
Yes, it doesn't really help very much. I mean, it's easy to say, but it depends on each case.
Yeah, I mean, as you say, I mean, the question is whether that's the crucial factor. But yeah, I mean, there's situations where you want to get a person who's got technical expertise, or who is just a very efficient arbitrator. For example, getting a professor, a former professor who's run a lot of arbitrations is a really good option often, because you get the ability to do legal issues in a predictable way, but then you get someone who actually can run an arbitration. I find it's not nice to say, but a lot of academics really don't have administration skills, and that's a very big aspect of arbitration. Yeah. Do the other panelists want to add comment on this particular issue, or do we move on to the next question?
Can I just add something? Like, I would say that it might be a crucial issue, but maybe the crucial issue would not be itself this special relationship, but the uncooperativeness. I mean, the thing where an arbitrator would not be willing to cooperate, and this may really ruin a good relationship, and this may become a big problem during the arbitration, because taking a decision on appointing of an arbitrator, it is sometimes always not clear what you will actually get, because you choose a CV in general, but in fact, in the end, you are like one-to-one, or maybe not one-to-one, but like a firm to one person. But actually, in this relationship, you are dealing with a person, and it may be tough sometimes. So like in practice, I would say that it may appear that sometimes the relationship is more important in dealing with a person, but it should be some kind of a balance. Like, you may not be too close, but if you are getting in a distance which becomes too long, like a longer distance, it is also very problematic.
Yeah, absolutely. Yeah, it's better finding the just milieu. Let's go to Leonora Guerra-Giacomet's question, which is a question on this particular issue. And then we'll move to the two other questions, which are more general. Actually, one is more general, one is for Solveiga. So the question Leonora asks is, how do you think we can overcome the comfortability factor? What do professionals looking for appointments do to be visible or considered a potential appointment? So yeah, Leonora's rightly saying, there's a situation where a prospective arbitrator doesn't really have had the opportunity to make those relationships, which do take time. What do they do to make those relationships? What do they do to overcome this factor at all? Accepting as I certainly do, that a relationship is really one of the big factors in the mix. So what do you do when you're starting out as an arbitrator to get into that position?
Well, I think, Phillip, you said it, the first 20 years are the worst, which I think is an exaggeration, to be fair. All you can do is you attend conferences, you attend, seminars, you talk at conferences, you talk at seminars, you go to arbitration-themed events, you get known, you write perhaps. It's really like any other professional activity. You get your name out there in whatever way you can. It's all you can do. And yes, unfortunately, luck. You have to get your first appointment. And I was very fortunate. But, you can try to a certain extent make your own luck, or put yourself in a position where, if you wish, luck is more likely to occur. I guess it does. Perhaps this goes back to your point about relationships, Phillip, that if you are known to somebody or some people with whom you have professional relationships, shall we say, that helps. And I don't see any difficulty in saying, well, look, I've taken a step in my career, advertising the fact subtly that you now are looking for appointments because this is something you want to do, and being humble. There are various organizations that have got panels for very low value disputes and so forth, and seeking to join them, which are open to much more junior practitioners. It's not a very helpful comment, I'm afraid. The comfort factor. I mean, the comfort factor, of course, plays in a number of ways. I can see the point about, knowing someone and seeing that potential arbitrator is a reasonable, sensible, flexible person is important from the point of view of the parties. But of course, equally the case with arbitrators, where you've perhaps got a panel of 3 and the 2 party-nominated arbitrators have to choose the third. They're going to look for somebody with whom they feel comfortable, and they're going to shy away from somebody who may be brilliant, but is a very difficult person to deal with. I mean, the last time I was on a panel of 3 and we had to choose the third, we consciously thought, well, actually, yes, we do need to be diverse, and we will choose a woman who happened to be known as it was to the other arbitrator, and it worked very, very well. I think one just, you've got to be aware of the comfort factor and analyze or interrogate yourself to the extent to which this is overcoming perhaps other factors which are as important.
Absolutely. Any other comments from our panelists on this issue?
No, I just want to add in. I mean, I don't want to preempt my talk when I get to it, but I think when I talk about Spain, I think you'll see that the comfort factor pretty much predominates here. This is you can kind of see where this goes in the extreme example. So anyway, we'll get to that.
Yeah, absolutely. Yeah, I think it is a very big factor in practice. Yes, I would add to what Charles and Peter have said is that a good way to start when one doesn't have rich and long relationships in the arbitration community is to get appointments from institutions. When you look at Steffen's analysis, you can see he doesn't talk about relationships. And the institute thinking about that. In fact, they're thinking the opposite. Steffen's thinking about, whether you have credibility as an arbitration practitioner. And he talks about some of the factors that he really appreciates in young people. For example, that you get the job done, you're open-minded, you've got knowledge about IT and practical things. Those are crucial things. I would say 9/10 of the arbitrator's activity is basically, I'm going to say, administrative. Yeah, if you can demonstrate an ability to manage a project to an arbitration institution, that's a good way to start getting those first appointments. And that actually gets you relationships. As I mentioned, one of the things you do when you're in an arbitration is look at the arbitrators and the other counsel and see that's a relationship. We might spend 4 years with them and you get to know them very well and how they behave in the particular circumstances. The other thing I would suggest is that one can focus on a particular sector. Arbitration is a vast sea, but you can sort of make the waters a little more manageable by focusing on a particular industrial sector. Which creates arbitration, anything in, for example, sale of goods, et cetera, or marine technology or something that goes to arbitration. Charles has done metals and finance, for example. People will focus on these particular activities and get sustained relationships through them and credibility. Not just credibility in terms of expertise, substantive expertise in the particular technical area, but credibility in as far as comfort is concerned.
I just want to volunteer something. It's interesting. It might I don't know, viewers might find it interesting, but one model that I don't know, people often overlook is what FINRA does in the United States with securities disputes. People broker dealer disputes and things like that. And FINRA has I think it's basically an algorithm that selects the arbitrators, really just on the basis of, affinity, to the case, experience. Basically on a series, the variables in the algorithm, just, how much experience you might have, etc. And the short list is randomly selected by the algorithm, and then ultimately, I think the FINRA staff picks a panel of 3, and and they're usually somebody complaining that they got ripped off by a broker or something. And it's a great, in the States at least, that's a great way to get started, serving as a on the panel. And there's no cocktail parties, there's no networking event, it's all pretty straightforward, and it's a great way to get into that. I think you won't make money on it. I think they pay you like, maybe $400 a session or something like that. But it's I mean, you can just imagine the amount of disputes in the United States, people complaining about being ripped off by some broker, So yeah, I just want to throw that up because I'm not sure whether there are models out there in the world like that. I think it's something definitely worth looking at. I mean,
well, I mean, I think maybe algorithms is taking it a step too far, but I'm sure.
Of course, but
Steffen will correct me, but when looking for an arbitrator, and they've got a bank of arbitrators who've submitted CVs or questionnaires or whatever it might be, there'll be a word search. You want to isolate those arbitrators who've got experience in metals as opposed to, I don't know, cosmetics, rather different industries. I don't see anything wrong with that.
Right.
Of course, then that leads to arbitrators peppering their CVs with all sorts of keywords, but there we go.
Yeah. Okay. Thanks. Solveiga, did you see the question from Leonora about your comment that you once changed the language of the arbitration to English from, I think it was Lithuanian? And why did you do that? And this particular question is, how do parties determine whether their English level is sufficient to overcome the challenges of regional language and legal system expertise, given that the documents may be in regional languages? So yeah, you made that choice. What were you thinking? What are the limits to that?
The problem is, as I told, the variety and circle of possible independent arbitrators. Because if we can have Lithuanian legal law as an applicable law, it's not a problem. You may have a foreign and solve the problem with the expertise, taking expertise. But if you have Lithuanian language as an arbitration language, then we have really limited circle of arbitrators who can handle the cases in that language. That's not obvious. And I had such experience in Lithuania in a big case and the big business the dispute among big business. And it was a problem just to find an arbitrator who could go through the conflict of check process, because you need an experience, really very focused and knowing how business work arbitrator. So it means practicing in a law firm, usually a big law firm. And either one party or the other usually are on some point of connected companies, clients for the law firm, and then you just cannot have him or in your case. Of course, you can try. There was even some kind of solution or suggestion maybe to have all the type translator, but how you can have translator among and ensure confidentiality in the panel of the tribunal. So that's the problem. Yeah. A very big one. So the thing what the parties are not very fluent in language is, I think, the less problem than the ability then sometimes to have a right candidate.
Yeah. Okay. Yeah, we have an anonymous attendee asking us about approaching candidates for our arbitrators and what the limits are. In the interest of saving time, I'll just answer very briefly. It's always delicate to approach an arbitrator on an ex parte basis without the knowledge and involvement of the other side. But there is an exception. You're allowed to check things that are not substantive and that are, not going to be material elements of the way the decision is made and how the decision will be made. So you can, for example, ask about availability, et cetera. You can probably even ask about experience and things like that. But at the end of the day, the arbitrator will be the gatekeeper. She or he will be the person who's going to let you know whether a question is inappropriate. And you can, within those limits, approach the prospective arbitrator directly. There are various guidance on that, and you can find that on the internet. I propose we move on to Yanina's presentation. And Yanina, you're going to speak about a global arbitration institution, in particular the perspective of Paris. Yanina, please do begin.
Yes, hello, Phillip. Thank you for giving me the floor. And actually, I was going to talk about global perspective, but mostly from the point of view of how it goes in Paris, because Paris arbitration market is rather a global market. And the thing that I'm currently stepping in as a speaker here, it's also kind of an indication that the Paris market is very global. Originally, I'm from Siberia with qualifications from New York and also Spain and France and Russia. And I'm an attorney of the Bar of New York and of the Bar of Moscow. Meanwhile, I'm also studying in Spain and teaching law myself at the Paris University, Paris to Panthéon Assas. And I've been working for almost a decade in Paris with the major international law firms and local law firms, mostly in arbitration and commercial law. And I would like to say that in Paris, of course, it is necessary to distinguish between local and internal and international arbitrations. And of course, as regards internal arbitrations, they will be more local. And as regards international arbitration, it will be mostly international markets. And if we're talking about global firms that are based in Paris, of course, when they're searching for their arbitrators, when they're dealing with whom to select as an arbitrator, it may sometimes not be a process for the Paris office itself, but sometimes it may lead to a nomination of an arbitrator for the whole firm, for some other offices. And of course, it will be on a very global market. And of course, as my fellow colleagues, I will also cover such issues as maturity, availability, expertise, independence and impartiality, diversity, language, and the issue of judges, whether actual or ex-judges as arbitrators. So moving on to the first issue, I would like to tell you a story of some story of a nomination of an arbitrator when the firm was not very interested and wasn't very much aware of the consequences of nomination of an arbitrator that actually was rather close to another party. So finally, the issue of this arbitrator nomination was that he was not very cooperative. He was biased. He was more inclined to to pass all the decisions to the benefit of another party. And I think that mostly the problem started from the very beginning. That was the person that wasn't very well chosen. So he was chosen mostly because another party proposed this person, but like all the other issues were disregarded. So I would suggest that from the beginning, a person that needs to have an arbitrator for a particular dispute takes due regard to this issue and thinks in advance whom he selects as an arbitrator and really takes this question very seriously. So as regards maturity and experience, of course, that is the major issue of all the arbitrator appointments. First, you need somebody who has the necessary experience, but he should also be mature enough to be an arbitrator. If we're talking about a big law firm, even such kind of a preliminary question to every single person of an arbitration department of every single office of a firm may actually be asked. So, do you know this person? Can you recommend him? We are considering him for a potential arbitration appointment. Sometimes this may be the case. And sometimes, because arbitration, of course, it's a big world, but at the same time, it's a small world. So if we're talking about the world of international arbitration, that may sometimes help, because if it is a very big law firm, of course, some of the workers may disclose some information that may be interesting, or that may be that may cause some issues with respect to the bias of a potential arbitrator nominee. Of course, dealing with an experience like it is the hardest in the process of the arbitrator due diligence. That is how the process of the selection and consideration of the nominees is called at these law firms. So all the experience which may be relevant to a particular dispute in question is actually considered. But not only experience is considered. A partner of a law firm may also ask to do some research with respect to the participation in various events. What were the events about? Especially if the events have some implication of a particular legal issue, for instance, fundamental change of circumstances that may arise in many arbitration disputes and an arbitrator that has more experience dealing with these issues, even if he's like participating in events with respect to these particular kind of disputes, well, of course, it will be taken into account if he has this experience of participation in events that cover this topic. Of course, articles and publications at different arbitration or other books may be also relevant and may be taken into account. So if a person is indeed looking for being appointed as an arbitrator, an advice to give is like to present all his articles, all his publications at one place, so that a person who is researching on potential arbitrator nominees has simply all the information at one place, and so that it is easier for a person looking for these particular experiences to search this information at one place, because sometimes there are arbitrators that might have this particular experience or particular expertise dealing with such questions, but it is so deeply buried in the other information available with respect to this person that you may never get to this through this dump of information. So, like, as regards the issue of whether it is more relevant to appoint an academic or a law firm worker, I would say that in my practice, for instance, we never had this issue. As long as a person is competent, as long as he has had some experience dealing with this particular type of issues, academics are also welcome. And at least in my experience, I have never seen like academics being most disfavored with if compared with practitioners. So I would say that academics are also welcome. As regards previous abbots, I could say that and it might be maybe an interesting observation for some people. Sometimes previous positions of arbitrators in previous disputes may be indeed taken for granted, as well as the sum of the average, even though the sum of the average is something that is objective, that may not even depend from the perspective of a nominee, but at the same time, even sums are sometimes looked at. Of course, an important issue is an availability. As my colleagues have already commented, it may be difficult to find a person that will deal with this particular dispute, who will not have a conflict of interest, but who may also be available. Especially it is an issue for small disputes. So if we are talking about small disputes, maybe it might be wise to contact an institution that deals with a particular type of disputes. And if it's a small dispute where like big names, important arbitrators may not take place, may not be interested in, maybe it might be wise to look for new names, to look for some like starters, arbitrators that have never participated in dispute resolution, that would be willing to start as an arbitrator and that would be willing to start these small cases, and that is sometimes in practice, at least here in Paris. As regards expertise, normally we assess expertise if we look at a particular efforts rendered by a particular arbitrator. So especially it may be good when Jus Mundi publishes such efforts, and it is actually easier in investment arbitration, and it might be much more difficult in commercial arbitration, where there are still a lot of efforts that are confidential to get this knowledge of the expertise of a particular person. As regards independence and impartiality, of course, as of now, we have many tools that assess how impartial is this person, whether there is some conflict of interest. For instance, Jus Mundi has a very good tool assessing all direct and indirect conflicts of interest. And of course, as regards indirect conflicts of interest, there are too many of them, and maybe most of these conflicts of interests, mostly they are to disregard. But as regards, of course, direct conflicts of interests, they are necessary to be brought before persons so that he is aware of the existence of this conflict of interests. If a person has dealt with some sort of firms for a long period of time, of course, some kind of impartiality issue may arise. And of course, with other regards impartiality, it is not easy because many of the issues, they may never be available on public databases. It's all about a relationship between people, and sometimes it's not easy to research, it's not easy to investigate. Hiring a private detective, it's not always an option, of course, though sometimes, of course, it might be the only option available for the parties if they would like to know if a party is completely unbiased or not. Moving on to diversity, I have never met a lot of issues with respect to diversity, because we have had women arbitrators appointed as well, and we have had at most of the law firms I was working with, we were considering and were giving due regard both to male and to female candidates, and it was never an issue as long as a female has the same experience, has the same expertise, and she is available. Well, no matter whether it was a woman or a man, I would say that in my experience, she would have been considered. As regards language in Paris, of course, if it's a Paris-seated arbitration involving parties in Paris, language is normally not an issue because many parties speak French as well. It's not a rare language. But if it's a Paris-based arbitration, but if a dispute actually concerns parties abroad, yes, language may also be an issue because Paris is not limited to parties that are seated in Paris. So language issues, they may arise as well. As regards the issue of judges, both actual and ex judges, well, in my practice, it has never been a question, but I would say that it is not very common to appoint an ex-judge in Paris. And I would say that there are some limitations. And it is not normal based on the French law, and it's not normal for a French judge to be appointed as an arbitrator. Maybe an ex-judge it might be more. It might be like easier. Thank you for. I see that my time is expiring, so thank you so much for your attention.
Yanina, many thanks. That was very complete. In the interest of time, let us move straight on to hearing from Peter, the Spanish perspective, and we'll return to questions if we have any time, because I do note we want to finish at midday, which is 17 minutes from now. Peter.
Okay, well, thank you very much, Philip. Just first off, I just want to basically say I agree with everything everybody said so far. First off, before getting forward, I mean, I am from Spain. I am a Spanish lawyer, but as you can hear from my New Jersey accent, I'm also an American lawyer. So just in case you were thinking there was something wrong with your computer, look, I'm going to come into this from a little bit different direction. I mean, up till now, I've been listening very interesting to what should we look at when we try to select arbitrators. I just wanted to share with you, a different perspective. Like, in other words, how does it really work? So in this country, I think the number one thing, the starting point is always the context, right? I mean, so I think it would be wrong to say Spain is a hostile environment to arbitration, but it's certainly not as friendly as England or the United States. So the arbitration in Spain does not benefit from the deference that an English judge might have for an arbitrator award, or a U.S., a New York judge might have. Here, it's quite a minefield, right? So this arbiter. I mean, let's say in the UK, let's say maybe 4% of arbitral awards are challenged a year, versus here it's maybe 16, right? So the point being, because it's a very extended concept of public order, right? So the judges love to crack out public order and challenge awards. So there's almost always a second instance here, right? So in selecting your arbitrator, I guess the first thing that you need to have is somebody who really knows how to walk that minefield. Like, because it's not just so much whether or not the award oh, you forgot to take something into account, or you forgot to admit some evidence, but no, like any of the procedural orders along the way is potential for challenge, for either for recognition or enforcement. So the result of that is that generally Spanish arbitrators are, for the most part, Spanish lawyers, generally from litigation background. There are exceptions to that. There's a handful of people like myself, who hail from different jurisdictions. There are quite a few academics as well. I mean, so I don't think having been a Spanish litigator is actually determinative, but it is quite often the profile. With that said, and pardon me for wasting my time just explaining it, but I think if you don't, you really do need to kind of understand the context, right? What that leads to, though, is that there's basically two situations, right? The very unsophisticated party with a very unsophisticated lawyer, like the lawyer that does everything for you, and they'll be in a dispute, and they'll ask the lawyer, hey, find me an arbitrator, you know, the guy will select anybody, you know, and oh, here's the next judge here, you know, so you'll have arbitrators who have absolutely no training, no experience whatsoever, because that's how they got selected, you know, because they were considered to be on side. The more sophisticated route, right, is to go to your sophisticated law firm who will apply these criteria that we've been talking about here today. But, you know, ultimately they will have a short list. They'll have a short list of people that they like working with. They've always liked working with. Oftentimes they'll be former partners of those same firms who've spun off into little boutique outfits, you know. So, you know, so you've got that endogamy already worked into the system. And so, you know, the short, you know, and I hate to say this, and I hope I don't get sued for saying this, but there's a blacklist, you know. I mean, oftentimes the first question is who not to pick, right? And there are arbitrators who are sloppy. There's arbitrators who are messy and sloppy and slow, and that's very valuable information to know who they are. And that's not something that Chambers likes to list, right? So, you know, that's also part of this game as well. Speaking of the list, I mean, the list, like, you know, who's who and Chambers and, you know, this whole industry of rankings. What can I say? I mean, they're really not a list of who you're going to pick. That's really more a scorecard. That just tells you who's getting the cases. A lot of great arbitrators are not on that list. They can't afford to be on the list because it costs a lot of money to get on the Chambers list. They spend their money elsewhere. And I would say the blacklist, don't get me wrong, I'm not accusing anybody of cartel behavior. It's what any professional group of people do, you know, to just control, you know, who, you know, a little bit of consumer protection, really, just make sure that your client isn't getting a dud. You know, I could go on and on about this, but I mean, I think, you know, on the issue of availability, I mean, I think here, and I think you could probably say this about anywhere else, that, you know, some clients, again, depending on their level of sophistication, they want a rock star. They want the brand. They want the branded Coca-Cola, not the store, you know, generic. They want the real thing. And, you know, and the client insists on that. And well, yeah, you know, you're going to have to wait 18 months until the guy's available, or he says he's available, but he really doesn't have time to actually do it, you know. But the firms usually blame that on the clients, right? So, no, well, the client insisted. You know? You get that. You know, on all the other factors, you know, about the language and training and, you know, managerial skills or industry specific skills. I mean, I think there's, you know, of course, they're all important and relevant, and ultimately, you know, if you're actually given an opportunity to get into that, well, I mean, of course, that stuff gets taken into account, and it's very, very important. I think I would say, and it's probably unfairly, I mean, I think one of the issues that I think needs to be looked at more here is just more of the ethical issues too. I'm not sure there's a very ugly case here about, you know, arbitrator misconduct, and I'm not quite sure the local arbitral institutions are really as on top of it as they should be. You know, I think some work needs to be done. I think also, you know, other factors too, you know, people's technical, you know, capabilities with technology and things like that. I mean, I don't think those are considered must-haves as qualities. I think just to close out, because I know we're running out of time. In fact, I'm not even looking at my thing here, but just to give some time for wrap up and all. I think there are limited opportunities really for up and coming arbitrators, because it is very much a you know, a little society where people, you know, there's a lot of conferences and seminars and dinners and you know, things like that, and because as in any business, I mean, it is important to stay top of mind. And people haven't seen you in a while; they don't know what you're up to, and so it's nothing really to criticize. But it just seems to be more of a determinative factor than it should be. I think that would be that's what I would say about that. Yeah, and so yeah, and you know, and I don't think also that I'm really saying anything about this jurisdiction that you might not find these challenges at any other, really. I just think that you know, Spain is making a big push now to try. You know, they just started their international arbitration court. They'd like to they'd love to compete with Paris and London, but I don't think, you know, I think if they really want to get there, they really do need to address some of these things. It shouldn't be such a clubby thing. It really, you know, it really should get out of that. It's very old fashioned. So anyway, sorry for, you know, anyway, that's yeah, that gives us what, 8 minutes left, right? Okay.
I think it's super. Yeah, thanks, Peter. I mean, yeah, it's interesting what you say about Spain and the particularities of the market there. Valuable information. Yeah, we do have very little time. We have some excellent questions, but I'm afraid we're not going to be able to do justice to them. Yeah, yes, I do apologize. I think what I would suggest is that I would just give the panelists an opportunity to make any final comments. And if there are none, I propose that we bring our proceedings to a close. So panelists, if you'd like to comment on anything in particular that has come up, even answer some of the questions, a rich area of questions, comment on what others have said, raise particular points, please feel free to do so.
Yes, may I start, please?
Yes.
Yes, I've just wanted to comment on the point that it is wise to note that it is not in Paris alone that we are dealing with these short lists of arbitrators. I have noticed that it is a very common thing. So like people have also noted the same in Spain, people have noted the same in Lithuania. So actually, I think it's about a generalized practice. And I think that the process of selection of arbitrators in different jurisdictions in general might have many things in common. Thank you.
Yeah, absolutely, Yanina. Yeah. Further comments?
So Solveiga, will you?
Steffen, you the first.
Okay, thank you very much. Just a few comments about some of your statements about a public list of arbitrators. We don't have that in Denmark, and I guess this short explanation is that it's not so difficult to get the right people on such a list. The problem is to get rid of them again when they are not right. For instance, if I had the task to explain to a Supreme Court judge that he's become too comfortable in his role as arbitrator, he's become too lazy, or don't pay enough attention to the cases, it would be a difficult task for the institute to do that. So we don't operate such lists, and as I said, the short version is that it's very hard to get rid of people again. Regarding what Charles mentioned about suggesting that people should go to courts rather than arbitration in small cases due to the considerations about costs. I think there's surveys. I think there's an old one from ICC suggesting that 85% of the costs in an average arbitration is allocated to pay the party representatives. So it's a big part of the budget. It's probably to pay the lawyers and the experts rather than paying the arbitrators and the institute. And you still have to pay the lawyers and the experts for going to court, and you should also bear in mind that the court system or the court decisions are subject to appeal. So maybe not double up, but at least additional cost in case of appeal, which is usually not available, that instrument in arbitration. Yeah, and the last point was that a good way to climb the ladder as a young practitioner is to work as a tribunal secretary. It's very popular here in Denmark, and it gives you really valuable experiences, which we also very much take into account when we are trying to appoint young arbitrators here in Denmark. Thank you.
Yeah, and Solveiga.
I just wanted to speak from the perspective, maybe young lawyers who really dream to become good arbitrators. What could be the some kind of suggestion? So, because it was one point raised during the discussion, that my question would be whether I would wish for my kids to become arbitrators. Honestly, to say, I would say no, because the way it may be very difficult and long and unpredictable. So for my kids, I would wish something more predictable, stable, and realistic. But in any case, those who really want, they have not to stick on the goal to become arbitrator. They have to stick on the goal to be good professionals. The best versions of themselves, and then maybe you will be lucky, because you have to be lucky in that area in general, and then you can go through. This is it, my advice.
I love that. It's true.
Okay, well, excellent. I think we're running out of time. That's I think a very nice note to conclude with, Solveiga. It's probably right that very few people actually are full-time arbitrators. It's like being a professional golfer. You know, great life, you know, if you're the top 5, yeah. But it's a rare thing. The nice thing, unlike with golf, is that you can integrate being an arbitrator into legal practice and various other lines of work, and it can be, you know, a top off and something that's very special alongside the other stimulating work you're doing. I'd like to thank our panelists for their very stimulating and insightful comments, and for you attendees for your participation and your excellent questions. I'll just remind that in our 2 series of webinars, the next installment is on comparative arbitration practice. It is on the party-arbitrator relation next Tuesday, 3rd of December. And as regards our fundamentals of counsel practice series, on the 10th of December, so in 2 Tuesdays, we have a webinar on drafting facts and law sections of statements of case, formulating requests for relief. So as concrete and useful to your practice as the present webinar, it is hoped, has been. Thanks all. Bye-bye.
Thank you.
Goodbye.
Bye.